Welcome to the Juris Law Podcast.
Hello and welcome to the Juris Law Podcast with Kimbro Stephens and Shane Cox. I am your host, Kevin Rosenquist. Kimbro serves as managing attorney and Shane is the chief legal counsel at Juris Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. Kimbro, Shane, great to have you back.
Great to be here again.
Thank you.
So today we're going to talk about special needs planning, how to protect the benefits, secure the future. It's a bit, it's a special area, obviously. So I'm excited to talk about this and learn more about it. In a nutshell, what does special needs planning mean, and how is it different from general estate or elder law planning?
Yeah, so that's a great question. A lot of times we have minor children that may have been born with a disability. Sometimes we have adults that have had an accident and are now disabled, or just through health over time have not been able to work and they go on disability and things of that nature. But a lot of times when we talk about special needs planning, we're really talking about disabled adult children that were disabled in childhood. And as opposed to what we might call supplemental needs planning for an older person to shelter assets for as they get older. Nevertheless, special needs planning is really designed around protecting assets of the person while they still qualify for SSI or SSDI or Medicaid or Medicare, or those kinds of health benefits, whether or not they're on a waiver program with a state so that they get some subsidized housing, maybe they got some independent supervised living, whatever arrangement they may have. A lot of times those are resource-based, meaning that if you have over $2,000 to your name or some other things, you may lose your benefit. So what good is that? So there are special needs that need to be preserved as far as government assistance and medical assistance. And that's what the planning is for, is to be able to, let's say you have a family member who passes away and has an inheritance. You don't give it to the child outright. That's what the special needs planning is for, is to put it in a special needs trust. And again, that's intended to preserve the resources of a family member without disqualifying someone for benefits. And essentially that includes Social Security benefits as well.
Okay. And you mentioned SSI and SSID. What do those stand for?
SSI is supplemental security income. That's usually people that never worked because they were disabled as a child, so
Gotcha.
they never paid into Social Security. As you get older, and let's say you've worked for at least 10 years or what we call 40 quarters and paid into Social Security, then you can qualify for Social Security disability insurance. That's SSDI. You're getting an insurance. It's not a supplemental security income because that's a safety net for the disabled and the poor that were never able to work. So in this society, we don't like people sitting on the street corners. I know a lot of people do and beg, but there is an SSI supplement for those people who can't work and are disabled. SSDI is for people that have been able-bodied in their lifetime for a period of time, and then they get on insurance. I hear some people say you paid into Social Security, and when you need it, Social Security is there to help you with insurance later in the form of a disability income, so you can live, essentially.
And is it especially important to plan carefully when you have a family member that relies on government benefits like Medicaid or SSI?
The special need planning is a part of your planning of your estate concerning your beneficiaries. So in other words, you have a beneficiary that might eventually need government assistance. So, and it happens all the time. You hear horror stories where someone has passed away and then suddenly the person actually on government assistance gets this big payoff and gets kicked off of government assistance. That's exactly what this is designed to prevent. So, and it's not just for government assistance too. Sometimes the person might not, as Kimbro alluded to, they might just not be good with money because of some problem they have. So you have to have a person, a trustee involved to hold the money, to give it to them, not just to keep them from being disqualified from government assistance, but also to make sure they can take care of themselves and not blow all of it at the same time.
Yeah, that's important.
Yeah. Very important. Yeah. So you got to be honest, when you beneficiaries in a plan, you have to be honest. Is this person, are they going to be okay with receiving a sizable chunk at one time?
A lot of times with our trust planning, we don't always know who's disabled in the future because sometimes things change. So as a contingent part of a plan, you'll always have a contingent special needs trust that can be implemented at the time that a recipient is to receive an inheritance if they're on disability at that time. And so proactive planning provides for an opportunity for that contingency in the future. You may say, well, I mean, I don't have anybody in my family disabled now, but you might. And at the time of your death, you need to have that in your plan so that you don't inadvertently, create a problem for them.
So within a special needs trust, can you kind of unpack more about how that's different, how it protects eligibility for public benefits, and just kind of unpack that a little bit for us?
The special needs trust, there are different types for different circumstances, but one is a self-settled special needs trust, and that means that I've got money, but I'm on SSI. And how did I wouldn't have been on SSI if I'd had the money. So now I've been in a car wreck and I got a big judgment. Okay. Or my great uncle who didn't have any heirs gave it to me while I'm on disability. Now I have money and I'm going to be disabled. I'm going to be kicked off of SSI and my Medicaid and everything. In those cases, we call it a self-settled special needs trust under the government that will allow that person to go ahead and set it aside. The key about that is they cannot be their own trustee in this case because someone else has got to make the discretion of whether they get the money back or not. But the kicker in those kinds of trusts is the government will allow you to make that transfer without a penalty of losing your benefits, as long as when you die, if there's any money left in that trust, it goes back to pay all the government benefits you've been on in your lifetime. Mm-hmm. So that's like saying, well, you're going to pay me now, you're going to pay me later. That's when you don't plan and someone ends up with a bunch of money. The best kind of trust is when I've created a trust for my loved one that might be disabled one day, so that it's not their money going into a trust as a self-settled when they get it. It's what we call a third-party trust. It's my money. I'm putting it in a trust for my loved one. And so now they're not going to get kicked off benefits. And the best part about that kind of trust is, and the beneficiary can't be trustee either because there's a discretionary thing in there about whether they can receive it or not. But now, since it was my money that went in there, my money doesn't go back to pay the state off one day when my loved one passes away. I get to decide. It goes on down to other family members. So again, that's the benefit of planning ahead. If you don't plan ahead, that loved one may have to create a self-settled trust, and then, that money may end up going back to the state one day. So, we don't want to set the money on fire, so to speak.
Is there any particular, how would a family know what type of special needs trust they need?
So sometimes it depends on, are they on SSI or on SSDI? Because those are different. For one thing, SSDI is not resource-based. SSI is resource-based. So again, SSI is way more complicated to deal with. SSDI, you have more flexibility. So depending on your type of disability may depend on the type of trust. Again, that's what the consultation is with the client about. We learn more about, what kind of resources are we talking about, who owned the resource, where did it come from, and that sort of thing. So I'm not sure I'm really answering your question there, but, really the type of problem we're dealing with usually originates from whether or not someone was disabled as a child or they became disabled later on in life, and whether they're on what we call SSI or SSDI. There are some benefits to being on SSDI. You have more flexibility with your planning. Otherwise, SSDI is the more difficult one.
Okay. And what kind of expenses can a special needs trust cover without jeopardizing a beneficiary's benefits?
So there you go again. What's the difference between SSI and SSDI?
Guess I just need to know that.
Yeah. But if you're on SSI, you cannot pay for a number of things on behalf of the person, or you can lose benefits. One of them is you can't pay for housing. If you pay for housing, it will reduce the SSI recipient's benefits from SSI. If you're on SSDI, you can pay for anything. It doesn't matter because it's not resource-based and it's not technically not income-based.
Okay.
SSI is both income-based and resource-based, so that any money if you give an SSI recipient cash out of a trust, you're going to lower their benefits dollar for dollar if you do that. Don't do that. You just don't. You can pay for, healthcare expenses directly to the provider, but you don't pay the recipient the cash to pay the provider. That's a no-no. If you're on SSDI, well, now you got a lot more leverage. You can give cash to the person on SSDI, but depending on if they're on Medicaid or not, they may not be able to keep a lot of money in the bank, but that's okay. You can still give them cash. And, so you've got more flexibility. So I guess the key thing, the key to that is you can pay for just about everything if you're an SSI recipient, except for housing. And that includes, utilities like electric and gas. Doesn't include, cable or anything like that. It's called the essentials. And you can't give them cash, period. Mm-hmm. But so those are the no-nos. SSDI, you don't have any of those limitations.
Okay. I don't know. I'm a sports fan, so I think cable is essential. I really do. Well, I don't know if I can get away with not having that. How best can families plan for future caregivers or trustees, especially when parents, thinking about the fact that eventually they may no longer be able to serve in those roles?
Yeah. So, I mean, that's it's one of the steps in doing the overall estate planning for the elderly person. And so the best time and the best way to do this is to, honestly, is to come and speak with an attorney that you can trust and just go unpack every situation that's going to come into play in this plan, and the beneficiaries and, their circumstances, whether or not there's a likelihood that they actually might end up on government assistance. All this will be kind of factored into how we design the plan for the elder, and it'll help us understand whether or not, that beneficiary will even, fall under the purview of a special needs trust.
Yeah, essentially we just do contingent planning up front. We don't know the future. I don't have a crystal ball here in front of me. I mean, I can tell you that there may be things that are likely or less likely to happen, depending on the circumstances of the family dynamics and so forth. But if you do an estate plan, we always allow for special needs and supplemental needs trust within that can go into effect at the time that they need to. And what I tell my clients is it's just paper, if you need something, it's just paper. It might be kind of thick, but it's just paper. If you need it, you need it. If you don't need it, well, it's just paper. Mm-hmm. So let's err on the side of having more paper sometimes, because all these things that in life that may happen, you'll be ready for it. Hopefully better than if you just did nothing. And so we do make provisions for unforeseeable events, essentially. That's what we do.
There are certainly obviously different levels for special needs. Some people, are somewhat, functional on their own. Some people really, really aren't. What do you take into consideration when you're trying to figure out the right trust, when you're trying to figure out the right plan? Is if someone has a child who is completely dependent on them and will be for their lives, does that change your approach?
Well, it certainly means that on the front end, there's not a contingency in place. There's a certainty in place. This child needs something. And so this is not a hypothetical anymore. This is a real situation where we know this child is going to need some protection down the road and is going to need a structure. So we don't really wait at death then to do that. We can create those trusts now. We can be funding them now. We can be putting money aside now. We don't have to, and we can be determining the trustees now to manage those funds. Maybe you have family members that want to contribute and things like that. If you have a trust now, you can be receiving those donations from other family members or whatever. Other family members who might want to leave something to that child can write it into their plans that they're going to leave a certain amount to this trust and so forth. So we can do that up front, knowing that that's going to be the case. And we always encourage the trustees of those trusts. We may put language in there saying we want to be able to esteem them and to be able to live as independently as possible. We want to make sure that they have social activities and family activities and recreational activities. You can even designate a care manager to help manage those situations, and you can create roles within the trust for people to do certain things, So it's real important to plan that out, because really what you're doing is you're creating a safety net for your loved one over time, because, Medicaid may not be here forever. You just listen to the news these days. So, you try to do what you can to provide for your loved one along the way, because, one of the biggest fears is who's going to take care of little Johnny when I'm gone. Right. You hear that all the time. I can't die. Someone's going to who's going to take care of Johnny? So you have to, have those things in place. And once you do, then, you're not so worried anymore, because, somebody hopefully has agreed to participate in this child's life, so that, you're not just, the child is not just having to fend for themselves one day.
For anyone listening who knows they need to start the kind of this planning process, what's the best way to begin? What should they consider? What should they get together before they talk to people like you guys?
Essentially, what helps us, if you want to be proactive and streamline the process, is for you to kind of get your thoughts in order as in terms of like what your estate is, what all you own, who's going to be involved in your estate, as for example, who may be your trustee or power of attorney, all your beneficiaries, kind of, and this hits on what we're talking about right now, kind of what we can expect from your legacy, you put in there. So, and if you need something to help keep up with that, you can always call our number, and we'll get a form to you that actually goes through some of the ins and outs of this. It's about 5 pages, but it's an inventory form. So if you had that filled out and gave it to us ahead of time, it would definitely help us and streamline your consultation.
Really, the first thing is awareness. You should be aware of what the circumstances of your child are. And we don't like to tell people they have to prepare anything to come see us. I mean, obviously, like Shane mentioned, we need to know what they have and who in their life, they trust, and those sorts of things. But there's no barriers to entry here. I mean, the first step is, let's be aware that we probably need to do some planning. And so the first step is come see us, come see a lawyer, start the conversation. You just need to start with a conversation. You don't have to be ready, because you don't know what to do. You're coming to us for advice. We have the consultation, and we start talking about the circumstances specific to your situation. And then we can develop a plan to move forward along with something that, you're comfortable with. Because really, the biggest problem, again, like we've said in some other podcasts, is getting started. I mean, it's getting started, and we don't want anyone, hesitating at this point. So we just tell people, come as you are, bring your stuff, bring your documents, bring whatever you have. We'll help you review them, but the first thing is I can't help you till you come see us.
Mm-hmm. Yeah, that's a really good point. You gotta be ready to go down this road. That's the first step for sure. All right. Well, thanks for tuning into the Juris Law Podcast with Kimbro Stephens and Shane Cox. For more information or to connect with their team, visit jurislawgroup.com. And don't forget to subscribe to our channel. Leave us a review if you can. We appreciate it. I appreciate you guys. Kimbro, Shane, always great chatting with you guys. Thanks for your time.
Thank you, Kevin. Appreciate your time today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.